It's my pleasure to introduce Gene Friedman. Gene is a long-standing union employee side lawyer, also a member of our advisory board. He's with the firm of Friedman and Anspach. He's spent many years representing the Teamsters Union. He'll be introducing our luncheon speaker.
Good afternoon, everybody. Although I am, as Sam said, a union side lawyer, I deposit my ideological hat at the door today for the privilege of introducing our luncheon speaker, the Honorable Kate O'Scanlan, who was confirmed in December by the Senate as the new Solicitor of Labor. Ms. O'Scanlan brings her considerable skills and talents to public service. Following a family tradition, her father is a judge on the Ninth Circuit Court of Appeals. Ms. O'Scanlan comes to public service after about 12 years at Kirkland & Ellis, where she was a partner handling complex litigation and transactional matters. She is also a Notre Dame lifer, 4 years undergraduate school, 3 years in law school, and is also on the board of the Notre Dame Law Association. The critical skills she learned there and the concern for others that she developed in her pro bono work and her work for Catholic Charities, I think will serve her in really good stead in her position as solicitor. The solicitor is the third-ranking person in the Department of Labor. She's responsible for all the legal affairs of the department, overseeing hundreds upon hundreds of attorneys. So it is a very large task, a very responsible task, and more so in the kinds of times that we're facing today. Just a quote from the mission statement of the Solicitor of Labor says, "It's to ensure that the nation's labor laws are forcefully and fairly applied to protect the nation's workers." And to that end, Ms. O'Scanlan has listed among her priorities, she wants to develop clear guidelines so employers understand their obligations to their workforce. She wants to incentivize employers to comply with the law and to ensure the benefits and rights that the workers are entitled to. That's, I think, something that both sides, labor and management, can join in. And if her responsibilities as a solicitor is not sufficient, she's also the mother of 4 children. So we all look forward to her. We appreciate what I think will be some wonderful leadership from Ms. O'Scanlan. And we welcome her here and congratulate her, and thank you for spending time to speak with us today.
Thank you, Gene, for that kind introduction. If I look a little tired, it's because I stayed up late watching our Capitals secure the Stanley Cup. So I don't know if any Caps fans are out there, but it's a great night for Washington, and I think we can safely say that politics were put aside at least for one evening in D.C. last night to cheer the Capitals on to their victory. As has been mentioned, I'm Kate O'Scanlan, the Solicitor of Labor, and it's my great honor to be here with all of you today. When I first entered Francis Perkins back in middle of January, I joined the ranks of 700 talented and dedicated new colleagues in the Solicitor's Office, some of whom are here with me today. This includes nearly 500 attorneys and almost 160 support staff nationwide tasked with ensuring that the department continues its multifaceted and important enforcement work. Enforcement work that ensures employees have access to safe and healthy workplaces, the pay and benefits they've earned, and equal opportunities to succeed. Enforcement work that allows job creators to train and hire new employees, build their businesses, and continue contributing to a growing economy without red tape getting in the way. enforcement continues to be a priority of this administration because it allows us to provide clarity about DOL responsibilities and goals. But under the current administration, enforcement is multifaceted and requires a comprehensive approach to achieving compliance with our stakeholders, or from our stakeholders. We recognize and appreciate that the vast majority of the regulated community care about their workers and simply want to follow the law. So we're strengthening our efforts to demystify the regulatory landscape. But we also recognize and understand that some choose to ignore the law, and this harms workers and employees alike. Thus, we remain committed to using all of our enforcement tools, including litigation, when necessary. So as you can see, we are engaged on all fronts at DOL, from regulatory reform to new compliance assistance initiatives, to providing clarity, to good old-fashioned enforcement. In short, we at the Department of Labor are committed to helping our stakeholders achieve growth in a number of different ways. With that overview, I'd like to turn now to discuss in detail 4 key aspects of the department's current work. First, I'll discuss several initiatives that we're working on to modernize and reform programs to better assist today's workforce. Second, I'll discuss highlights of DOL's regulatory efforts. Third, I'll discuss DOL's work on compliance assistance. And finally, I'll discuss some of DOL's important enforcement initiatives. First, in an effort to provide more assistance and support to the regulated community, we're working on several new initiatives. For example, we are modernizing the H-1B non-immigrant visa program to suit today's workforce needs. DOL is committed to ensuring proper use of worker protection provisions of the labor certification programs that under our jurisdiction. As many of you know, these visa programs are vital to growing the American economy. This administration recognizes the need for significant reform, however, in the non-immigrant workspace. Abusing guest worker immigration harms U.S. workers, U.S. employers playing by the rules, and non-immigrant visa holders. So at the department, we are reshaping our non-immigrant visa programs to better suit the needs of the American employers and workers. First, we're configuring how employers apply for H-1B visas. H-1B visas allow employers to temporarily employ foreign workers in the United States in specialty occupations. Occupations with unique requirements that demands candidates possessing discrete skills and a bachelor's degree or equivalent. In this highly publicized arena, we are actively developing proposed changes to the labor conditions application, which will provide greater transparency and protections to U.S. workers and businesses using the system properly. Next, the department is also encouraging confidential, credible sources with knowledge of abuses of the H-1B system to provide information to initiate investigations. We're using all investigatory tools available to conduct civil investigations. Fraudulent schemes in the H-1B space deny U.S. citizens opportunities for good jobs, deprive honest immigrants the opportunities for jobs and advancement, and threaten the security of the United States and its citizens. While we understand that H-1B stakeholders generally comply with laws, protecting the system from abuse by a few bad actors levels the playing field and protects workers. So the department is committed to making sure that employers have the skilled employees necessary to grow their businesses. But all must follow the rules for these programs to work to the benefit of employers of the American workforce. Another important administrative initiative is apprenticeship programs. DOL has placed tremendous focus on American apprenticeships earn and learn model and of training to get people the skills they need for in-demand jobs that lead to family-sustaining career paths. As technology is fundamentally and rapidly changing the nature of our work, our stakeholders are rightly concerned about the skills gap, the significant divide between the skills the workers have and the skills that available jobs demand. While employment numbers are very encouraging, millions of Americans remain unemployed even while more than 6 million current job openings go unfulfilled. Secretary Acosta has been at the forefront of proposing solutions to support the American workforce and to close the skills gap. An ongoing challenge at the department is communicating the value of apprenticeship programs across all parts of the economy, so this model for training workers is fully maximized. The Secretary believes that the apprenticeship model is a strategy that works and is therefore a top goal of the department to expand the reach of apprenticeships to the variety of industries and sectors. In order to address the skills gap and grow apprenticeships more broadly, the department is working to provide additional options for employers. Consistent with this goal, on June 15th of last year, the President issued an executive order on expanding apprenticeships in America. The executive order calls for industry-recognized apprenticeship programs that will allow for stronger industry partnerships. The department is working on several fronts to create the framework for these programs. One critical piece of that work is the Secretary's task force on apprenticeship expansion. Because there is no one-size-fits-all approach to apprenticeship, the department sought input from a variety of stakeholders regarding how to make train-as-you-go model applicable to a wider range of industries. The Secretary of Labor, Commerce, and Education engaged with the task force members to identify strategies and proposals to promote apprenticeships. The task force issued its final report to the President on May 10th, relaying its findings for expanding the use of this training mechanism. The department is encouraged by the continued interest and support from the regulated community and looks forward to working to modernize the apprenticeship model so it fits today's workforce. We're also working to proactively help address the opioid crisis. On March 20th, 2018, the department announced the National Health Emergency Dislocated Worker Demonstration Grant Program to help communities address economic and workforce-related impacts of the opioid crisis. The goals of these grants include to study and test different ways to address economic and workforce-related impacts of the opioid epidemic, provide training and support activities to workers and those otherwise impacted by the crisis, and provide training to grow the skilled workforce in professions that could impact the causes and treatments of the opioid crisis so that we have people trained to help address the many layers of this epidemic. The department anticipates 7 to 10 demonstration projects with anticipated funding of between $500,000 and $5 million. The program is necessary and encouraging step in addressing the opioid crisis, and we're very optimistic about that it will result in improved training for responders, much needed data to help address this problem on all fronts, and support for those most intimately affected by this crisis. Let's now turn to my second point to discuss some of the regulatory work going on at the department. First, the tip credit rule. On March 23rd, Congress passed the Consolidated Appropriations Act, a bill that, among other things, prohibits employers from keeping employees' tips. As a result of this legislation, employers who do not take a tip credit and pay the full FLSA minimum wage may establish a tip pooling arrangement between front-of-the-house staff, like servers and bartenders, and back-of-the-house staff, such as cooks and dishwashers. Congress enacted the bipartisan law after Secretary Acosta's testimony before the House Appropriations Subcommittee on Labor, Health, and Human Services and Regulated Agencies. During his testimony, the Secretary supported passage of a law barring employers from taking tips. After inclusion of these key provisions in the recently passed budget bill, the Wage and Hour Division issued a field advisory bulletin to address its enforcement of the tip credit rules under the FLSA. The department is also working on a rulemaking proposal that would align its regulations with the statutory amendment. FAB 2018-3 confirms that employers who pay the full federal minimum wage may now allow non-traditionally tipped workers to participate in mandatory tip pools. This means employers may create arrangements where servers share their tips with other members of the team who are equally integral to the customer experience. The FAB also confirms that the Wage and Hour Division will immediately begin using its new enforcement tools to protect American workers' tips, including recovering all tips unlawfully kept by employers and imposing liquidated damages and civil money penalties where appropriate. This is an important and timely update to the law that will put more money back in the pockets of workers. You may also be wondering what's happening with the overtime regulation. On July 26, 2017, Wage and Hour published a request for information to gather public input to aid the department in developing a proposal to revise the regulations. The department received over 214,000 timely comments on the RFI, which we're currently considering as we develop a proposal to revise the regulation. Until the department issues its final rule, we'll continue to enforce Part 541 regulation that went into effect on November 30th, 2016, including the $455 per week standard salary level. What about association health plans? On January 4th, 2018, the Department of Labor announced a notice of proposed rulemaking to expand the opportunity to offer employment-based health coverage to small businesses and sole proprietors through association health plans. The department received and reviewed over 900 comments, and the final rule has been sent to OMB for review. The rule provides a fix that would allow for more small employers and sole proprietors to band together and provide an association health plan. By participating in such an arrangement, employees of small employers and working owners would be exempt from the regulatory complexity and burden that currently characterizes the market for individual and small group health coverage. AHPs could therefore enjoy flexibility with respect to benefit design and tailor benefits to the needs of their employees. The final rule is part of the department's spring regulatory agenda. Persuader. The Labor Management Reporting Disclosure Act requires labor organizations, consultants, and employers to file reports and disclose expenditures on certain labor management activities. One of these activities is when employers hire consultants to persuade employees on organizing and bargaining issues. Under the prior administration, the department issued a final rule that required employers and their hired consultants to report whenever the consultants persuaded workers directly or indirectly with regard to their rights to organize and participate in union activities. The rule expanded the type of persuader activities that were reportable to the department. Shortly after the rule was issued, the department was sued for declaratory and injunctive relief, vacating the persuader rule. A federal court in Texas issued a nationwide preliminary injunction against the persuader rule in June 2016 and a permanent injunction in November 2016. The department has proposed to rescind the persuader rule, and a notice of proposing rescission of the rule was published in the Federal Register last June. The comment period ended last August, and we recently submitted a draft of the final rule to be reviewed by OMB. I'd like to take just a few minutes to discuss my third point regarding some of the tools available at the department that are designed to provide guidance and support to the regulated community, such as the PAID program. As Brian Jarrett likely discussed yesterday, Department of Labor announced plans for a new program called the Payroll Audit Independent Determination, or PAID program. PAID is available to employers seeking to resolve limited minimum wage and overtime claims under the FLSA and provides a framework to work more collaboratively with the regulated community to assess and correct violations before they become enforcement actions. This program will also allow employers to minimize their legal fees associated with these claims and permit employers and employees to implement changes immediately. We plan to run the PAID program nationwide for approximately 6 months, evaluating effectiveness and at the end to determine next steps. We're encouraged by the initial employer interest in the program and urge all FLSA eligible employers to participate in this pilot. Opinion letters, as Brian also may have discussed yesterday, we announced last summer, or Wage and Hour announced last summer its intention to reinstate the issuance of opinion letters. This action will allow Wage and Hour Division to use opinion letters as one of its methods to provide guidance to covered employers and employees. The letters were a division practice for nearly 70 years before being stopped and replaced by general guidance in 2010. The division has established a web page that the public can see if existing agency guidance already addresses their questions or can submit a request for an opinion letter. Switching gears to OFCCP, they also offer robust compliance assistance for contractors who need or want help complying with their obligations. OFCCP has several compliance assistant tools available on its website, including the Federal Contractor Compliance Manual, FAQs on a range of topics from jurisdiction to contractor requirements, e-law advisors, guidance documents from all 3 laws enforced by the OFCCP, and a list of upcoming seminars and workshops. The agency is also actively involved in revising and updating fact sheets, webinar materials, FAQs, and guidance to reflect regulatory changes and make materials more accessible to the contractor community. In an ongoing effort to work more closely with the regulated community, OFCCP held 3 listening sessions with stakeholders regarding ways that the agency can improve communication and collaboration, expanding training and providing more written guidance. OFCCP takes this input very seriously, as the agency is committed to expanding compliance assistance programs to create more balance in carrying out its mission. As a result of these sessions related to the GAO report, the agency issued a town hall action plan to provide more clarity to the regulated community. According to the action plan, OFCCP will review and enhance contractor compliance assistance, replacing outdated technical assistance guides with 3 new comprehensive technical guides, assess and improve the quality of contractor and compliance officer training and education, and increase transparency and communication with the regulated community. OFCCP is committed to providing a compliance assistance that will help federal contractors understand and comply with their obligations under the law. OSHA also maintains the Voluntary Protection Program, where employers, labor, and OSHA work cooperatively to implement comprehensive on-site and safety and health management systems. As long as employers maintain VPP status with OSHA, they are exempt from OSHA programmed inspections. Under VPP, employers are reevaluated every 3 to 5 years for their continued eligibility for the program. OSHA funds a robust consultation program through which state agencies offer smaller employers comprehensive guidance on developing their own safety and health programs, complying with OSHA requirements, and generally improving conditions for their workers. These programs provide an opportunity to work cooperatively with the consultants and are a vital part of our ongoing effort to assist stakeholders with their compliance responsibilities. Finally, OSHA offers sample safety and health programs, which are intended to provide examples of written programs on various workplace health and safety topics. It is our hope that all stakeholders will take advantage of these programs and improve access to safe and healthy workplaces. EBSA also offers the Voluntary Fiduciary Compliance Program, or the VFCCP, or the VFCP. VFCP is designed to encourage employers to voluntarily comply with ERISA by self-correcting certain violations of the law. Many workers can benefit from VFCP as a result of the increased retirement security associated with restoration of plan assets and payment of additional benefits. It will also help plan officials better understand the law. The VFCP describes how to apply the 19 categories of transactions covered, acceptable methods of correcting violations, and examples of potential violations and corrective actions. Finally, with all of the collaborative projects right now at the DOL, I should remind you that we are still an enforcement agency. Let me now overview some of these enforcement activities. DOL enforces over 180 labor laws. Our core mandate is to enforce these laws. But as you know, the department's overall budget has been trimmed to ensure that we are spending tax dollars more efficiently. This means we need to use our enforcement resources intelligently and strategically. So while the agency is actively engaged in rulemaking and deregulation and engaged in compliance assistance initiatives, DOL's enforcement action work continues. We are still pursuing major litigation on many fronts, including the OSHA Act, ERISA, the FLSA, Labor Management Reporting and Disclosure Act, and anti-discrimination and employment provisions set forth in Executive Order 11246. One thing I learned long ago about Secretary Acosta as a former federal prosecutor, he's a strong believer in the rule of law. And under his leadership, the department will continue to enforce the law. These enforcement efforts ensure that employers and plan sponsors have a consistent basis for helping employees plan for their retirement future. They ensure that workers are protected from falls, trench collapses, crushing accidents, and incidents of workplace violence. They ensure workers receive the pay that they earn. They ensure that workers are protected from discrimination in the workplace. And they ensure an even playing field for all employers so that dishonest or unprincipled employers cannot benefit from skirting their responsibilities under the law. In our efforts to support DOL programs and advance agency enforcement priorities, the Solicitor's Office continues its critical work advocating before the administrative and federal courts. For example, we recently secured nearly $30,000 in back wages and civil money penalties, resulting in violations of the H-2A non-immigrant worker visa program, and a 3-year debarment against companies for individuals in violations under the Migrant and Seasonal Workers Protection Act. While the non-immigrant visa programs are vital to growing the American economy, they are often ripe for abuse. This is why the department is committed to vigorous enforcement of the worker protection provisions of the labor certification programs within our jurisdiction. Our attorneys in other spaces also play an important role in promoting workplace safety through OSHA enforcement. We continue to pursue fall protection violations because these are necessary measures that save lives. We recently worked with the Department of Justice to obtain a guilty plea in a favorable civil settlement in a case where an employer knew that a construction site where it deployed workers lacked sufficient scaffolding to protect all the employees from deadly falls. Foreseeably, when the worker was killed when he fell from a third-story balcony while simply doing his job. This tragedy occurred because the employer allowed at least half of the employees to work without fall protection instead of ordering additional scaffolding or providing other sources of fall protection. Sentencing in that case will occur soon. Our attorneys are involved in all stages of the case, helping OSHA with the initial investigation, the issuance of civil citations for willful violations of the OSH Act, through referring the case for criminal prosecution, collaborating on the criminal case, and obtaining a civil settlement in which the employer dropped its challenge to the OSHA citations. We're also continuing to pursue matters in the whistleblower space. We're currently trying a case under the Surface Transportation Assistance Act. In this matter, the employee, a recent trucking school graduate, notified his employer that the truck assigned to him had major safety issues. Instead of fixing the truck, the employer instructed the employees not to use the main roads in order to avoid state inspection patrols. However, knowing that the vehicle was too dangerous to operate, the employee again objected. This time, he refused to operate the truck because the brakes were so faulty that they disengaged while it was being unloaded. Instead of fixing the brakes, providing a different truck, the employer terminated the employee for raising the concerns. We're currently litigating this matter, seeking emotional distress and punitive damages of over $70,000. Thank you for allowing me a few minutes of your time today to give you an overview of what's going on in the Department of Labor. And happy to take a few questions to the extent there are any.
Thank you. Jim, you have any questions?
I have no questions for Mrs. Gallo.
Okay. I want to ask you a question about the paid program. We had some terrific presentation, by the way, by Greg yesterday. There may be a limitation on employer take-up because you can't shield the participating employer, no matter what he does, from state law claims.
Right.
And employers will feel in a difficult position, sort of confessing error. Now, I know DOL has no jurisdiction over state law. I understand that. But is there some thought being given to partnership arrangements with participating state agencies so that you can, in some states, offer that extended release?
I can't speak to anything specifically that I have knowledge of, but I think that I will bring that up with Brian Jarrett, and I don't know if he spoke about that yesterday, but it does make some sense in terms of the full resolution of claims to the extent there's also state claims, and I understand that, you know, obviously we can only do that which we have jurisdiction over.
Right, a number of states, I think, would participate with you. Other questions or comments? Over there? Could you identify yourself, please?
Sure. Hi, this is Ben Penn from Bloomberg Law. I wanted to ask, it's been about a year since Secretary Acosta withdrew the administrative interpretations on joint employment and what defines an employee versus an
You're not
independent
coming across too
contractor.
clearly.
So it's been about a year since the Secretary withdrew the two AIs on joint employment and independent contracting misclassification. Do you think it would be appropriate, since he withdrew them without replacing them with any new interpretations? I understood, I know he's explained his reasoning for why he withdrew them, but do you think it would be appropriate to use your office working with the Wage and Hour Division to consider issuing either a new interpretation, new guidance, new rulemaking on joint employment or misclassification?
Sure, well, I can tell you at least, you know, that we continue to fully and fairly enforce both the statutes in accordance with well-established case law and existing department regulations. And, you know, I think that the Secretary's withdrawal of the AI does not change long-standing legal responsibilities of employers under the FLSA or MISPA, for that matter. But I think that this is something that we are considering among many other areas. And I know that, for example, the NLRB is working on its joint employer rule as well, from what I've read in the papers. No inside information, but I don't know if Chairman Ring spoke about that this morning. But I know that it's a hot topic and it's something that we're all thinking about.
Hi, I'm Charlotte Alexander from Georgia State University, and I noticed you used the words enforcement and strategically in the same phrase, but not strategic enforcement. And so I was wondering if you could comment on the extent to which the DOL continues to use some of the strategic enforcement ideas that the prior administration had put into place, sort of targeting industries where workers themselves may not be likely to bring lawsuits to enforce their rights, or if the extent to which some of that has carried over, or if not, what sort of strategy you're using to guide the enforcement resources of the department.
Well, I think it's working hand in glove with our client agencies in terms of what they're seeing on the investigation, because, you know, solicitor's office gets involved at different parts depending on what the matter is, and earlier with some of our client agencies and later with some. And I think as I said before, in terms of litigation and whatnot, that can be a really powerful tool in enforcement. But that's something that we're looking as we're getting all the politicals settled in their individual agencies, and also as I'm getting to know my divisions and folks in the regions as well. But I think it wasn't intentional to not say strategic enforcement, because I don't know that there's such a distinction. I think that we just do not have the resources to bring every single lawsuit that we want to, or that maybe there is sufficient reason to. So I think it's, again, identifying the bad actors, and I think that also helps with our compliance assistance. I think also helps those who really do want to comply rise to the top, and it helps us distinguish who's wants to comply and or who's willing to comply where we find issues. So, hoping that as some of those initiatives get off, that we'll see positive results in that regard.
Hi. Chris Alfer, I'm also with Bloomberg Law. Just a quick question for you on, I'm curious what your thoughts are on potential criminal prosecution for wage theft. Under the previous administration, occasionally DOL would refer cases to the Justice Department for criminal prosecution as a form of larceny. I think the FLSA also allows for criminal penalties. Can you just tell us a little bit about how you might approach that issue?
Yeah, I have not dealt with that issue yet, just in complete candor in terms of, hasn't come across my office, but I'm getting to learn some of the tools in other spaces such as OSHA, where we work with the U.S. Attorney's Office when we think that there's a violation, and we're working with them on a criminal claim. But I will admit I am not a criminal lawyer. So I'm learning a little bit about some of those collaborations as I go on, but I can't speak to anything specifically in the field of wage theft. But I think we're open to enforcing our laws in effective ways, and strategically or not. So I think that would be something. I think that's something that we'll look at as these laws and regulations are developing.
Thank you.
The Pension Benefit Corporation is running out of money, and there have been reports in the news that over the next 10, 20 years, thousands of workers may be deprived of pensions that they've come accustomed to looking forward to. Is the Department of Labor taking any steps with respect to that?
I think that question would be better suited for my colleague Preston Rutledge, who is on the forefront of those issues and certainly is aware of them and knows that it's an issue. But I have not been involved in anything more specifically. But again, I think he would, the EBSA division would be the proper place for that to be happening.
Other questions or comments? Well, I see none.
Oh, I have one.
Where? I'm sorry.
Yeah, hi. My name is Matt Jackson. I work for the NLRB. We heard a lot at this conference about from Chairman Ring as well as from General Counsel Rob about how the NLRB has been forced to consider restructuring and some pretty dramatic measures to change the way it operates in light of budgetary restrictions. You touched upon certain budgetary issues that you're facing at the DOL. I just wanted to know if those pressures are, you're feeling the same kind of pressure to change the way you do business in your agency.
Thanks for your thoughtful question. I don't think as maybe severely in terms of structural. I can't speak to. I don't have firsthand or too much secondary knowledge of exactly about the restructuring that may or may not be happening at the NLRB. But I think that we're working with the regions and in terms of enforcement dollars and using those. But I don't have any plans for any major restructuring of them.
At this point.
At this.
I think there's a question from that side. Could you identify yourself, please?
I'm Dee Dee Minkiti from the New York Regional Solicitor's Office. You mentioned that that the administration is considering revisions to the H-1B program, and I just wondered if you could elaborate on what the administration sees as the primary flaws in that program and like what some of those changes might be.
Well, given that there's an ongoing rulemaking, I can't really talk more than what was in the NPRM. So I can only talk about what's publicly available. But I think that again, it's the modernizing it in terms of making it easier for the employers. But as you know, we only have one part of that program, so it's also working with USCIS as well, and DHS, who has the other side of that.
Any other questions or comments? Well, I don't see any. Thank you again.
Absolutely.